Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. This is an update on the matter styled as State of Idaho versus Stacey James Wondra. This proceeding deals with the tragic disappearance and presumed unaliving of Michael Vaughan from a small town where he lived with his family called Fruitland on the Idaho-Oregon border. Last year, Mr. Wondra was charged with the abduction and presumed unaliving of Michael, and he was ordered to stand trial following a preliminary hearing that was open to the public and that occurred earlier this year. Trial is now scheduled to occur in September of 2026. We note on the court docket that there is a sixth supplemental notice of compliance that has been filed by the prosecuting attorney for the county of Payette, which states as follows: comes now the plaintiff, the state of Idaho, and serves notice upon the court and submits a sixth supplemental response to the defendant's request for discovery. Plaintiff has complied with such requests by providing the defendant all information, documents, and reports in its custody and or control. Said response will be supplemented as appropriate. And this was signed by the Payette County prosecuting attorney, Michael Duke. What we have not yet seen on the court docket, ladies and gentlemen, is evidence that the defendant complied with the state's request for a notice of alibi if he so intends to raise the alibi defense at trial. Mr. Wondra, under our Constitution, is considered not guilty at every point of the proceedings until or unless he either pleads guilty or is adjudicated guilty following the September jury trial. Under our Constitution, moreover, he is not required to say a word. However, on occasion, defendants will raise an alibi defense, saying, for example, it couldn't be me because at the time of the crime, I was elsewhere. I was on a flight, and here are the materials proving that I was flying on the specific airline at the time of the crimes. Or I was at work. Here are my check stubs, timesheets, and here's the name of my supervisor who could confirm that I was at work at the time of the crimes. So at this point, it is unclear if Mr. Wondra will raise a defense of alibi. That demand was filed back in March, and there is a specific time frame under Idaho law when a defendant must provide information to the prosecutor upon demand for details regarding any alibi defense that might be raised at trial. We will continue to keep you posted as further developments arise. Until next time, thank you for joining us here today.